What is the first thing if someone has an injury on the job? What is the first thing that they do?
First thing that anybody who's injured on the job needs to do is they need to report that injury to their employer. That's the proper procedure. The employer will then report the injury to their insurance carrier, and there may be an application that has to be filled out or a statement. Once the insurance carrier gets the application or the claims form, that insurance adjuster is going to want to talk to that injured worker, probably take a recorded statement. I would suggest that the next person that you speak to after you report your injury be a lawyer, just to at least find out what your rights are.
Okay, so is it all, at what point should a person actually bring a lawyer in to their case?
Well, it's
because a lot of these can be handled
sure.
by workers' comp on their own.
Sure.
Right. Okay.
A workers' compensation claimant does not have to have a lawyer represent them. It's kind of a complicated process. So again, my advice is to contact a lawyer after you're injured to at least learn what your rights are. That's important because as professional as a lot of claims adjusters are, they're really not there to represent the injured worker. They have a job to do. So any questions anybody has about their rights under the workers' compensation laws need to be asked to a lawyer that handles workers' compensation claims.
And Andre, I was going to ask you, what is the difference as a workers' comp lawyer, for instance, like the statute of limitations or attorney's fees,
sure.
than a regular type injury?
Well, workers' compensation, the Mississippi Workers' Compensation Act has a bifurcated statute of limitations. In general, it's 2 years from the date of injury. You have to bring a claim, and that means bringing a claim with the Mississippi Workers' Compensation Commission. That means filing a petition to controvert. I said it's bifurcated. If an injured worker has received a disability benefit, then it's kind of an open air statute, meaning that there's no statute running until the employer and carrier, and that's what we call the employer and their insurance company, until the employer and carrier properly file a notice of final payment, which is commonly called a Form B31. Once a B31 is filed, the injured worker has 1 year to either receive an additional benefit or file a petition to controvert.